Well, good morning, everybody. Hopefully you can hear us all, and thank you for joining Fasken's annual year in review dealing with occupational health and safety and workers' compensation in Ontario, also known as WSIB Matters. My colleagues, three health and safety consultants with Fasken's and myself, would take you through about an hour and a half of review of what's happening, what has happened, and in Ontario, of course, a lot has happened in the last 36 hours. We're not going to focus so much on the new state of emergency issues, but go to a pre-organized, identified or researched summary of the last year's events, but some of the events of the last 36 hours will be touched upon as well. My colleagues are very qualified, experienced health and safety consultants, and in many cases paralegals registered with the Law Society along with myself. And we represent the labor and employment practice at Fasken's, a national business and international law firm that primarily gives advice to corporate clients in these areas, in our area of specialty, occupational health and safety and workers' comp. So let's go to this outline of what we're going to cover today. I'm going to talk a little bit about COVID. We talk a lot about COVID, but I'm sure a lot of you have already heard a lot about COVID. We're going to focus a little bit on occupational health and safety and WSIB implications throughout our time this morning. Want to also update you on what else has been going on about occupational health and safety compliance, about legal enforcement, and about the defense of due diligence. Due diligence, of course, is a defense that you may in fact need to think about in terms of the new Ontario state of emergency shutdown rules. And if you need advice offline, feel free to contact any of us. We're also going to talk about workplace harassment and violence. There have been a lot of changes over the years in Ontario, other jurisdictions, and now federally. What we want to do is give you a bit of an introduction to the new federal law changes, but more importantly, give you a broad best practices approach to the issue and the challenge of harassment and violence in the workplace. Workers' compensation claims management is our next topic. And it's important to realize that in Ontario, if somebody tests positive for a COVID-19 virus in the workplace, that's presumptively an occupational disease and reportable both to the Ministry of Labor as well as workers' compensation. So we're going to give you some advice on how to manage the workers' compensation aspect of this. All of us are going to have our contact information on a slide at the end of the presentation, so feel free to contact us after. We're going to try to have a little time as we go through each of the three major sections for question and answers, but time is limited, and we know your time is valuable. So without further ado, we're going to get into the next. So pandemic implications, if we can go to the next slide, are broad and overarching. Since the original shutdowns of March of 2020, Ontario, Canada, and the world has been on a challenging, difficult ride through the COVID pandemic. It continues to be a serious health risk, both from a public safety and an occupational health and safety perspective. So during the last 10 months, we've been helping clients with understanding public health guidance as it relates to occupational health and safety risk. The thing to keep in mind throughout all of this, and things are often changing in terms of guidance and laws, is that the virus coming into the workplace is a workplace hazard for workers and obviously others who come into the workplace. Your primary goal is to use the principles of occupational health and safety, hazard identification, or risk management to deal with the issue as a general guidance. So keeping the hazard of COVID out of the workplace has got to be your number one priority. And then being prepared to deal with it if it gets in the workplace with control measures is the other concept that safety professionals, like my colleagues, are well-versed with and have been helping clients with throughout. So from an occupational health and safety perspective, COVID still needs to look to the public health and safety guidance. Interestingly, there have been no regulations or occupational health and safety laws changed during the last 10 months. But a lot has changed in terms of the risk of COVID, and a lot has changed in terms of public health guidance. So we've looked to public health and safety guidance, and in some cases laws, to prevent infectious disease in the workplace, and that needs to be embedded in your approach to dealing with COVID-19 as a hazard in the workplace. So although there is no legal direction other than general duty clauses and other than the general principles in health and safety law, including the idea of the internal responsibility system and also accountability, so involvement of the Ministry of Labor Training and Skills Development, the new named formerly Ministry of Labor, is critical, because if it's not managed well, if the COVID risk of hazard to your workers is not managed well, you may be accused at a later date of having violated as an employer your general duty clause. And every statute, including but not limited to Ontario, has a general duty clause that has been referenced by regulators during COVID as being the guiding principle. The general duty clause for Ontario essentially says that employers have a duty to take every precaution reasonable in the circumstances for the protection of workers. You can extend that if you're a healthcare provider or retail outlet to anybody in the workplace, including your patients and your patrons. So that general responsibility needs to look then at your type of activity, your type of workplace, your type of risks, look at public health and safety guidance, and any legislation that might affect you directly. So for example, the new regulation passed late last night by the Government of Ontario requires certain additional screening precautions that we'll talk about in a minute, and updating of your COVID-19 safety plan. Is there an explicit requirement in the Occupational Health and Safety Act for a COVID safety plan? No. Is there one in the public health and safety legislation and the emergency regulation that was passed last night? Yes. So you can see hopefully that in managing COVID as an occupational health and safety hazard, public safety and occupational safety merge or are intertwined, and you need to be aware of both to be fully compliant. So we'll go to the next slide and talk a little bit about the screening tool. So Ontario required very little in the early months of COVID by way of a screening tool. And the screening tool is primarily a subjective self-declaration by the worker set out by Chief Medical Officer of Health as to what questions the employer must answer. The details of that amended in September and then amended again late last night. So you want to take a look at the regulations, you want to take a look at your screening tool today or tomorrow, very soon, and make sure that your required screening program in place is now compliant in Ontario with the new updated requirements. There also is a record keeping requirement that was introduced literally last night, so you're going to have to keep a better record. And that's of course for the idea of contact tracing. If you do have an exposure or an outbreak, 2 or more people essentially is the meaning of an outbreak in a workplace, then you're going to have to be able to cooperate with public health and perhaps health and safety regulators. And that means providing information on the people who have signed in and through the screening tool. So that record keeping is more important than ever. Next point is the safety plan. Hopefully you've been, if you're in Ontario and other jurisdictions where this applies, compliant with having a specific COVID safety plan. Now, of course, occupational health and safety law, including Ontario, has always required a safety policy and a program to implement the policy. And that's very contextual. In other words, it's contextual to the hazards of the workplace that every different kind of workplace in Ontario might have. In September, and before that, we were recommending that there be a safety plan for the specific hazard of the infectious disease COVID-19. That has now been enhanced as of yesterday, and you need to be able to have it updated and make sure it's current, and we're happy to help in doing that. But the reference to that COVID plan is in the regulation that was passed late last night, and there are some specific nuances that have been updated. But if you don't have a COVID-19 safety plan, you need one. If you don't have one, you are not legally compliant. And if it's not been updated, according to the regulation passed late last night, you're going to have difficulties. To enhance your occupational health and safety compliance generally, but in particular for the COVID infectious disease hazard in your workplace, you need to make sure you have a plan and that it's current and updated. Absent that, ignorance of the law is generally seen as not an excuse legally, and you could have enforcement issues. So enforcement internally is going to be the employer's responsibility. It is true that supervisors in Ontario also have a general duty clause, and some pressure will be on supervisors to make sure that they understand, are equipped, and are communicating with workers that they're responsible to supervise. But ultimately, the primary responsibility is going to rest with the employer. Last point I'd like to touch on briefly is the interesting and somewhat controversial issue of vaccine policies. We're delighted that in Canada, in Ontario, and around the world, COVID vaccines have been approved by a lot of FDAs in the US, Canada Health Department in Canada, and they seem to be quite effective or efficacious. That's good news. The challenge, of course, is supply right now, and now we know is being ramped out, and we're hearing a lot about that in the media. In the meantime, even before your employees, by and large, unless you're in the healthcare sector, which you should be getting them soon, employers should be thinking about having a policy. They should be thinking about the context and the type of workplace they have. They should be thinking about, do they want to take a bit of a bold step and require or make requirement before coming back to work vaccine mandatory with some lawful exceptions under human rights legislation, or do they want to take a softer, we strongly recommend approach? Quite apart from that fundamental issue of requiring by mandate or recommending by policy, there are going to be some nuances. So what happens if you're a supplier of services to a healthcare facility, a hospital, and by contract, you have to have your employees vaccinated with the COVID-19 vaccine, as with other vaccines? Are you able to do that? Do you want to give people paid time off to get their COVID vaccine? Do you want to ask for proof of vaccination for those who are vaccinated? And if so, how invasive of privacy rights is that? Or how important is that to know and to protect the safety of workers? So those are the challenging issues. There is no absolute law, rule, or mandate for this. We're having to go back to basic principles of occupational health and safety law, of the priority and challenge of balancing safety law vis-a-vis human rights and privacy concerns. But given the pandemic is so deadly in Ontario, Canada, and around the world, the balance of opinion seems to favor a strong policy requiring employees to cooperate unless there's sound reason. And not going to go into the details for the exemptions, but you need to understand there should be some exemptions to your vaccination. You want to have a strong recommendation, if not a mandatory policy, to do that. But it really will be contextual for your type of workplace, for the type of exposure risk your clients, patients, and employees have. And so all I'm really doing is flagging the importance, I think, of having a vaccine policy and working through that with your labor and employment lawyer that has expertise in health and safety law. So that's a key thought. So we're going to go to the next slide. And I'm going to jump in again with my colleague Cathy Chandler's help to the whole idea of trends. So to look more broadly at workplace trends in occupational health and safety on the first slide, there's a couple of interesting ones that have developed over the last 12 to 18 months. So we know, and you may not know, but we'll advise you now, that in Ontario and other jurisdictions, legal limitation periods for enforcement of health and safety law were suspended for approximately 6 months. So from March 16th to September 14th, limitation periods for commencing enforcement action or moving cases forward procedurally if they were prosecuting in the courts, for example, were suspended. So we've had to advise a number of clients that even though the limitation period of 1 year in Ontario expired during the COVID shutdown between March 16th and September 14th, that length of time is really added on, depending on the time of their event and the time that the 12 months limitation expires. And so many employers still are at risk for incidents that occurred more than a year ago. And if you have a situation like that and you want us to help you with that time calculation, feel free to give us a call. Two interesting cases came out of late 2019 and 2020 that you should be aware of. First, the George Rogue Roofing Corporation was an interesting case. It got resolved in 2020 during our COVID year last year, but it had a longer delay. So presumptively, what we're talking about is a constitutional right under Section 11B of the Charter of Rights and Freedoms that applies to individuals and corporations to be given a trial, a right to a trial within a reasonable period of time. The Supreme Court of Canada, a case called Jordan, presumptively for this level of court said that has to be done in about 18 months. So in the first case, the George Rogue Roofing case, the whole time period was over 3.5 years since the initial laying of charges. 2.5 years were administrative delay in setting a second trial. So it's an interesting case because they're going back for a second trial after an appeal. But the court essentially said, look, after 3.5 years since the first trial, this has just gone on too long. And there's some detailed facts that are very specific to that case and ruling that we're not going to get into for want of time. But the key point there is that if you have a case that's pending in the courts and or been delayed by COVID in an enormous amount of time, your charter rights, your constitutional rights to a trial within a reasonable period of time have not been suspended by the suspension limitation periods. You may very well want to get advice in your specific case as to whether or not you really have to go through with the trial or make a decision about whether there's a plea offer to accept it. But before doing any of that, really should get a legal opinion on whether your charter rights have been violated. The other interesting case is the Nugent case. This is a complex case that also had a parallel criminal proceeding involving a workplace fatality in a mine because of cyanide poisoning. The net delay in the Nugent case, Mr. Nugent and several other individuals charged under occupational health and safety regulatory charges, was 23 months. Clearly a violation of the 18-month rule of thumb set by the Supreme Court. But the trial court there, and approved now to go to the Court of Appeals, so this is a Court of Appeal decision, was that for a number of case-specific reasons, 23 months was not a violation of the presumptive 18-month delay, in part because of the parallel criminal proceedings, in part because of the complexity, in part because it was a fatality. So the 18-month rule of thumb is not always strictly enforced by the courts, as the Nugent case indicates. So those are two important updates in the law of your right to a trial within a reasonable period of time. In other words, pretrial delay being a reason that the defendant, the employer, or the individual doesn't have to go to court. So we'll go to the next slide. The other interesting development in substantive law for occupational health and safety law in Ontario is the definition of employer. So in the first bullet, I've actually put the legal definition of employer. And you can see that employer means more than really just the common law employee-employer relationship. I'm not going to read the definition, it's there. That interpretation, that broad interpretation, I think a reasonable one of the definition, came back in 1992 in the Wyson case, and I've cited it there. So what's new? Well, the Court of Appeal has given leave in a very interesting and somewhat complex case involving the city of Sudbury, and they're going to revisit this issue. So in other words, the city of Sudbury had contracted with a contractor to do paving. There was a terrible fatality involving a pedestrian by the contractor, and that issue was resolved on a plea for the contractor. The city of Greater Sudbury said, we are not the employer. The Ministry of Labor said, yes, you are, and we're going to prosecute you. And at trial, the trial court said, no, the city, even though they had a contract with the contractor whose worker was involved in the pedestrian accident, was not the employer. Well, the Ministry of Labor, now Ministry of Labor Training and Skills Development, said, no, we disagree. And they have got leave or permission to have the issue litigated at the Court of Appeal. So this is a really important issue, not only in construction, but more broadly for companies that contract out work. So the Wyson case is being revisited now, and the issues about when you contract work out and the contractor and their employee or their subcontractor has an accident, are you potentially responsible under the definition of employer? So this is going to be revisited. We're going to watch this case. We'll report probably next year, same time or similar time on this. But the takeaway right now is that simply because you don't employ somebody directly in a normal common law relationship, common law employment relationship, doesn't mean you don't have responsibility. The presumption under OHSMS is that you do, and that may be expanded if the Court of Appeal gives guidance in and when they decide the greater the city of Greater Sudbury decision. So we'll go to the next slide. And I just want to touch on due diligence, and then my colleague Cathy Chandler will provide some additional insight. Due diligence remains the defense for occupational health and safety, and essentially all regulatory charges include potentially COVID charges. If there's a COVID regulation you're charged with violating, or environmental charges, or technical standard and safety association charges, or any type of regulatory law that's not criminal but gets prosecuted in a quasi-criminal arena, criminal courts. And so I've got, as a reminder, in italics, the two separate defenses, and their numbers are added by us, of course, not part of the Supreme Court's decision, on what due diligence means. In other words, this kind of idea that even though you may have been provably in contravention of a law or regulation, for our purposes dealing with health and safety in the workplace, there still is a defense that you either had a mistaken set of facts, which if true would render the actor or omission innocent, or the more classic statement of due diligence, taking all reasonable steps or all reasonable precautions for compliance and to avoid the particular event. So presumptively, if you're being prosecuted, the particular event or adverse health and safety outcome, an accident, injury, or worse, has occurred. But there is a defense still available. And that is motivational, or should be motivational, for employers, because you want to invest in your occupational health and safety management system, your OHSMS, in whatever form it's in, because as you do so, even if something bad or something unforeseeable happens, you're likely going to be held accountable by regulators. We see a lot of aggressive enforcement still, even during COVID, of occupational health and safety standards in Ontario and across Canada. And you need to be vigilant, not just because you have COVID, but also because you have the risk or hazard of COVID, of people getting it in your workplace or bringing it into your workplace. So it's more important than ever to look at what it is that amounts to an effective occupational health and safety management system, because in our view, that is the essence, in practical and safety management terms, the essence of the legal defense of due diligence. So I'm going to turn you over now to my colleague Cathy to take us away on some additional details on the due diligence defense.
Thanks, Norm. So just expanding on what you've said with respect to due diligence, what exactly are reasonable precautions? Norm talked about a health and safety management system. What exactly is a health and safety management system? Suffice to say, it's not enough to have an occupational health and safety program in place. You need to ensure that the requirements that are set out in the program are actually being implemented in your workplace. So in other words, if you've got a safety procedure and workers don't know about the procedure, or they're not complying with the requirements that are set out in the procedure, then the fact that you've got a health and safety procedure isn't likely going to be evidence of due diligence. So an important part of health and safety due diligence really is being able to demonstrate that you're doing what you say you're doing. And this is challenging for a lot of employers. The conditions for establishing due diligence include several criteria, starting with a risk assessment process. So the intent of that would be to take steps to identify and assess all of the hazards and potential hazards that workers might be exposed to in your particular workplace. Obviously, that's going to vary depending on the type of workplace that you're in, the type of hazards that your workers are exposed to. You want to include, when you're doing this assessment, looking at the specific jobs that you're having workers do, the types of tools and equipment that they're operating, and really assessing the hazards that are associated with those tasks. And when that's done, controls need to be put in place to either eliminate the hazards or reduce workers' exposure to the hazard or reduce the severity of the hazard. And there's different types of control measures, including written occupational health and safety policies, practices, and procedures. When you're developing your health and safety policies, practices, and procedures, some of these are going to be in response to very specific regulatory requirements, like your workplace violence and harassment policy. That's a provision that's set out in health and safety legislation for employers across Canada. The fact that you need to have a workplace harassment and or workplace violence policy and program in place. But other practices, policies, and procedures are going to be in response to your specific workplace and how you want the work to be conducted to ensure worker safety. So an example might be development of a safe work procedure that you develop for a specific job or task where you've identified hazards and you've got a written procedure setting out how to do that work safely. Training and education is the next important aspect of the due diligence defense, or of demonstrating due diligence. So the intent of which is to ensure that your workers really understand and carry out their work according to your established policies, practices, and procedures. So again, it's not enough to have those policies in place if you're not providing your workers with training, instruction, and information on those policies. You also want to keep in mind that under health and safety legislation, really across Canada, employers have both general and specific duties to provide workers with training, information, and instruction. Employers should also be ensuring that you're training and educating your supervisors and managers on their legal duties and their responsibility and obligation to ensure that workers are following requirements that are set out in an employer's health and safety program. So this might include having supervisors talking to new workers about safety during orientation training, or meeting regularly with workers, having safety talks to discuss health and safety matters, inspecting areas of the workplace under their responsibility, responding promptly to unsafe conditions and activities, and paying attention to routine and non-routine activities that workers are doing, ensuring that workers understand hazards and preventative measures to be followed. So in this respect, supervisors really are key when it comes to monitoring the workplace and ensuring that employees are following your health and safety policies, practices, and procedures. Written documentation of progressive discipline for breaches of safety rules is also considered due diligence. Condoning unsafe acts, on the other hand, might be considered health and safety negligence. And finally, there should be an auditing component to your health and safety management system to ensure that your program continues to be effective and that it's meeting regulatory requirements. Next slide. So just to provide an overview of key elements of the health and safety management system, you're really not going to have a very effective health and safety management system if you don't have commitment from senior management. Management and workers in such situations can become cynical if they see that the top level message isn't being backed up with commitment and concrete evidence of accountability. So keep in mind that an effective health and safety management system really starts with and should be accompanied by accountability frameworks, which really demonstrate genuine management commitment and resources to health and safety. And certainly engagement of all of the various actors in the system is key, including support from unions and joint health and safety committees, where health and safety really is seen as an integral part of the well-being of workers and the organization. I'm going to pass it over to my colleague Carla now, and her and Norm are going to be speaking about workplace harassment and violence legislation and best practices.
Okay, thank you, Cathy. So there's been a lot of changes on the federal level regarding workplace harassment and violence, and where Norm and I are going to discuss, what those changes are specifically. But before we get into that, the down and dirty, I guess, of the regulations, I want to talk a little bit about statistics. I know the statistics it's an important tool to use. They need to be viewed as a trend. Some statistics, are skewed to what the information they want to present. But it's very important to understand, especially in the context of harassment and violence in the workplace, what are the trends and how did we get to this point where the federal legislation now has put in these new regulations and requirements. So this slide talks about global statistics. This information is from the International Labor Organization. And it takes a lot of information, different information globally from different countries, and it puts out these different various forms of statistics. So as you can see from this slide, there is definitely a global trend and an escalating of harassment and violence within the workplace. So as you can see, the United States is estimating that 27% of workers have experienced some type of abusive conduct at the work during their lifetime. Now, this was taken in 2014. We don't have the statistics of, well, how long is a lifetime? But, if it's during their lifetime, you can depend that that's a significant time frame of having abusive conduct. And as you go through the other slides, you can see again, Europe, 16% of workers reported exposure to adverse social behaviors. Japan, for example, 45% of representative samples of companies reported that they had issues about power harassment. You can just know that that's some type of a harassment. Maybe that's from somebody that's above them, or there's some type of a harassment due to somebody's authority, for example. But the most recent statistics are from Argentina and Chile. And it's showing that there is a trend for situations of violence and harassment in the workplace. So it is something to consider. It is something that it's just not in Canada, for example. If we can go to the next slide. So in Canada, we do have some statistics. Most of our statistics are very old. Some of them, this one, for example, on this slide is from 2016. It was a general social survey by Statistics Canada. It was a very small sample group. There was 9,000 persons that were interviewed in the survey. They ranged from the ages of 15 to 64, and they were in the course of employment at the time of the survey. So keeping that in mind, and then keeping these percentages of the responses in mind, you can see that 19% of women and 13% of men reported that they had experienced harassment in the workplace within the past year of this survey taking place. The most common type of workplace harassment was verbal abuse, as you can see, and then the next type more common was humiliating behavior. And provincially, we've been dealing with harassment and violence policies and procedures. We know some procedures will actually have definitions about what they consider harassment. Bullying is sometimes considered harassment. Humiliating behavior, of course, is considered a form of harassment. And it's very important to understand that harassment and violence are often put together because if you have harassing situations, they can escalate into violence in the workplace. So it's very important to understand, what do you mean in your policies and procedures by harassment? What is humiliating behavior? So that you can basically, correct that type of behavior so it does not escalate into any type of violence. Next slide, please. Violence, unfortunately, is very underreported. This information is from a US statistic. It's the National Safety Council in the US. We don't have a very good mechanism in Canada at the moment, provincially, for reporting violence. The only mechanism we have currently provincially is if you have a workplace injury or a fatality which was caused by violence in the workplace. That then is reported. However, if you have an incident of violence, we don't have a reporting mechanism for that. There are specific industries, such as healthcare, which do have these mechanisms. The healthcare industry does do a lot of industry-wide surveys. They are getting statistics within their industry in regards to harassment and violence. But as an overall, what is violence in the workplace in Canada, we can basically only estimate by these various surveys that are taken. As you'll see when we talk about the new federal regulations, there is a requirement for the employer to report annually about any types of harassment and violence that have occurred in the workplace. So we are now seeing on a federal level that there is going to be a mechanism for this reporting, and we are going to be able to track these statistics much better. But in the US, this statistic found that assaults actually in the workplace were the second leading cause of work-related deaths following roadway motor vehicle crashes that were in the course of employment. And this study also found that non-fatal work-related assault injuries continue to be on the rise. So even though there's not a true mechanism for reporting, we can see that assaults are climbing and that they are more prevalent within the workplace. Next slide, please. So this chart, this was from the Employment and Social Development Canada in 2017. And this is basically to show you that there was a question, for example, working with unstable and volatile persons. So of all the respondents, 47% answered yes to that question. Yes, I have worked with somebody that was unstable or a volatile person. And then from that 47%, we see that 87% of those that responded yes had experienced violence in the workplace due to that specific condition. And you can see that working with the public is very high as well. And then it was just these specific questions. So yes, the number, like working late at night, might be low from the respondents that were questioned. Yes, I do that. But of that, 28% had experienced some type of violence at the workplace. So you can see that, we do have a mechanism for tracking this, and we can see the trend is, okay, if you're working with somebody that's potentially unstable or a volatile person, or if you're working with the public, if you're in service, healthcare, you're giving advice, you're in education, those are also high. And you can see that the trend is really with dealing with the public more times than not. Next slide, please. So these are just, the next two slides are about best practices. And it's really reflecting what Norm will be talking about. Norm's going to go through the specific requirements of the federal regulations that have just been enacted. So this is just to give you an idea of things to keep in mind when you're looking at your violence and harassment. Some things will be legislated, other things will be how can I develop those and how can I make these programs, procedures more effective for my organization. So of course, there's going to be an assessment of risk. We do that in most provincial jurisdictions. We have to have some type of a violence assessment. Provincially, there's not so much the requirement for harassment. This is a new development within the federal regulations, which we will speak about. Within your assessment, you have to consider domestic violence. It's in both provincial and federal legislation. You need to develop measures for controlling this. With the federal regulations, they have come out with a template for a harassment and violence risk assessment tool. And it's actually quite a very good starting ground for you. And you can also use this provincially. You can adapt it to your organization, but it sets out, do I have the policies? Yes, no. Do they need to be reviewed? Should they be modified? Do they even have to be developed? And then you can look at, well, I do have something. So that's a control mechanism that's in place. So it's very good that this tool is, you're also assessing it, but it's very important to have that control aspect as well. And then you can look at your control and you can say, I'm not meeting the legislative requirement, or that's not good for my organization. So there is also an action column as well. So it's a very, very good tool that you can use. It's not mandatory, but it gets you started. And it might even get you to look at what you already currently have in place, adapt it, change it. It's a continual improvement aspect, which of course then ties in with any type of due diligence that my colleagues, Cathy and Norm, have already discussed. These need to be reviewed annually or more often as required. And then we just talk about your program policy, your programs. If you're large enough for a joint health and safety committee, they need to be involved in the development of any type of policy and program. Next slide, please. So these again are just some continuations. You should look at your incident reporting. And Norm again will be talking about this in greater detail on the federal level. how the investigations are going to be handled, third-party investigators. The big key with that is your communication element. You have to do what you say you're going to do. And the federal legislation now is mandating timelines for when all of these things are to be completed. So you have to be mindful of those as well. You need to have some type of an emergency procedure and how to summons assistance in the event of violence or harassment in the workplace. That has to be clearly stated, and you have to understand how is that communicated to my employees. Train everybody on your contents, and then you also need to consider some additional training. Perhaps your supervisors and managers, yes, we understand the policy and program, we understand what our roles and responsibilities are, but maybe there needs to be some additional training of how do I handle this situation? How do I diffuse somebody that is maybe volatile? What tools and what skills can I develop? What additional training can I provide to my supervisors and managers, maybe even to your human resource department? And then how maybe I need some additional training for workplace investigations. Okay, next slide, please. So Norm, I'm going to turn this over to you now, and Norm will go through some of the details of the federal regulations and things for employers to keep in mind.
Thanks, Carla. And just to recap, apart from identifying statistics and trends, what Carla's done is to remind everybody in the health and safety, human resource, and management at any level kind of responsibility that the problems of society, the challenges of society of harassment and violence really are those also of the workplace. And, legislation, both provincially and now federally, is attempting to deal with that. The realities of what's going on in the workplace, in the lives of your workers, your employees, that's something that you have to be managing. And surprisingly, but not so, violence and harassment is a key issue, a key risk, and needs to be managed, and legally you're required to manage. Before we get into the federal legislation, I'm going to answer orally here a few questions that have come up in the Q&A that I've been watching. It says, I've been listening to Carla. The City of Sudbury case dealt with the city as both an owner, and whether that means it's an employer, that's the issue going to the Court of Appeal, and also the constructor. The constructor issue was also litigated, but that's not the subject of the appeal to the Court of Appeal. We also had a question or two, very specific fact situation. For those may not be familiar with the requirements to be responsible as a law firm giving a webinar, we can't give specific legal advice during the course of a webinar. Obviously, we need to be retained by a client, or if you're a current client, you can speak to the labor and employment lawyer you normally deal with, or send me an email at the end. But we're happy to give advice, but it's in the context of retainer. That's Law Society guidance and firm policy. So apologies for not being able to answer a specific legal question that you've obviously sent in detail. And lastly, about vaccine policies, there's no government, federal or provincial guidelines on what a policy should have, but it is something that we recommend in the context of your responsibility for health and safety of workers. So whether you include it as part of your legally required health and safety policy and program, or whether you have a standalone vaccine policy, will very much, I think, depend on your approach to safety and management and legal compliance, the type of risk and initiative you want to take with your vaccine approach, and also the potential human rights and privacy issues. So it actually gets a bit complex. I would recommend against taking someone else's templated policy for vaccines related to COVID-19 and just putting your name on it as an employer. I think that's a dangerous practice. It's tempting, it's efficient in a way, but it's going to get you to probably more problems than you want. So again, if you do have a Fasken labor and employment lawyer you normally deal with, reach out to them. If not, feel free to contact me, and we'll help you with understanding and then implementing an effective vaccine policy. So let's get into the handoff that Carla's given to me on the federal legislation. Now, if you're not a federally regulated employer, and about 8 or 9% of the workforce in Canada is federally regulated and more than 90% is not, you may think, well, this is a waste of time. In our view, it's not, for three reasons. One, this is going to be talked about in the media a lot because effective January 1, 2021, the new regulations are in force. And we're seeing some media pick up on it. And your employees, even if they're provincially regulated, are going to kind of wonder what's going on. So you should be informed. Number two, it is the most recent of all health and safety law in Canada updates. And it reflects not just the federal view on this, but the more current thinking from a safety professional perspective on it. And what's interesting, it's become the management of health and safety law that deals with harassment and violence has become much more prescriptive, and you'll see that in a moment. But thirdly, even if you're not federally regulated, some of the very prescriptive and more recent trends that we see in this new legislation that I'm going to cover in a moment are things that we recommend you think about as a best practice. So they may not be legally binding on you, but in your jurisdiction, or if you're in Ontario, may not be always legally required, but it is something you may want to consider and review for updating your current policy because it, I think, represents in many cases a best practice. All right. So hopefully that keeps the rest of the non-federally regulated employers interested for the next couple of minutes. So let's talk about this. Well, the law is effective January 1, 2021. There's an interesting ambiguity in the training requirement, but every employee must be trained, every federally regulated employee must be trained in the legislation, in the focus on prevention of harassment and violence, in the new policy, in the new reporting mechanism, in the new investigation technique, and who you contact as your representative in your workplace if you have a complaint. All of that needs to be done. If you're a new employee as of January 1, 2021 federally, then you've got until April 1, 3 months. Ironically, if you're not a new employee, the way we read the legislation, and it is a little bit ambiguous the way it's drafted, is that you have until the end of the year, which makes it a bit bizarre, but we don't recommend you wait until the end of the year. We recommend you roll out in an organized and well-communicated plan your training and your training program. All right. So then to the next slide, we want to talk about the regulation. So it's a new regulation that has been passed under previous amendments to the Canada Labor Code Part 2 that deal with this. It's designed and intended to focus on prevention, but a lot of the content is in fact about what happens when, a lot of the new content, is what happens when you have a complaint and who you complain to, and a detailed prescriptive process of how that works out with specific timelines. So we'll go to the next slide. So it's Bill C-65 that was enacted several years ago that eventually ruled out this regulatory change. What's important is that there were some previous regulations that dealt with violence in the workplace, and they've now been replaced. So all federally regulated workplaces, unlike previous violence requirements under the Canada Labor Code, are now covered by this regulation. So it effectively simplifies and gives an omnibus regulation or an all-encompassing regulation for all federally regulated employers. So you can now, regardless of the type of federally regulated employer you are, look to the regulation and follow it, and you'll all be basically following the same rules. So let's go to the next slide. What is interesting, innovative, and very prescriptive in the new regulations is that effective January 1st, 2021, you have to have a written policy that has a number of prescribed elements. So it's not just a requirement, like in Ontario, to have a policy dealing with the prevention of harassment and violence in the workplace, but they're telling you how to do it. This is helpful. It also means that if you don't have all of these elements, you're not in compliance. So it's actually now more a rigorous compliance obligation by federally regulated employers to comply with the new regulation for preventing harassment and violence. Let me just touch on it briefly. You have to have a mission statement. You have to have a mission statement. I find that interesting. not a goal, not a statement of purpose or a statement of scope. Those are still probably different than a mission statement. You need to have a goal in the form of a mission statement. That's required by law. Second, you have to describe the role of employers and the responsibilities. The designated recipient, that's the person or entity that receives complaints. Employees, the committee, safety committee or policy committee if you have one, or if you're a small or federal or regular employer, the safety representative. Now, all of those parties, all those workplace stakeholders are set out in the regulation and given certain responsibilities. So what we advise against on this point is that you have to have it, but don't just copy and paste from the legislation. Explain in the context of your workplace how the employer is responsible, what the employee's responsibility is, et cetera, so that you've contextualized this and not just done a cut and paste from the regulation. Next, you have to actually identify risk factors for harassment and violence. This is interesting and innovative, and this is a best practice you may want to consider. So in other words, in your policy, you may very well want to say for the type of workplace we are, for the kind of customer, client, or patron we support, for the physical location of our workplace. Are we in the docklands of Vancouver or Montreal or Halifax? That may be a higher crime area. All of those, both internal and external risk factors, must be identified. And there's guidance on what risk factors are. They're very general in the regulation, but we recommend you don't just drop what's in the regulation in, because they're general and not all that helpful, quite frankly, but they tell you what you need to look at by both internal and external factors. So the policy development really should go hand in hand and perhaps be refined or updated after you do your hazard assessment of harassment and violence in the workplace, which is another legal requirement. So when you do this hazard or risk assessment with your applicable party, your joint health and safety committee or policy committee, that translates into how your policy is going to look. And doing this carefully, thoughtfully, engaging the input, respecting the input of the committee members, the safety representatives, if you're a small employer, is critical to having an effective policy that will be helpful in preventing harassment and violence in the workplace as it's rolled out, as there's training, but also survive scrutiny if there's a complaint or if you have a regulator, inspector, safety inspector coming in and looking for this policy, because the policy will be asked for, whether or not it's a routine visit or whether or not it's a complaint into an alleged incident of harassment or violence. You'd also need to provide a program for how you, in your policy, how your program of training is going to roll out. That's a prescribed element. You can't forget that. And then you have to get into a summary of the resolution process. Now, my colleague Carla and I have given 2, and next week we're going to give our 3rd half-day paid webinar on the new regulations in detail. One of the things we spent many, many hours developing, Carla's done a great job on this, is a flow chart for the investigation and resolution process. And let me just say, you need a flow chart because it's not simple. So what the policy, though, requires at this point is about the template for how you resolve things, or a summary. And you may not want to use the template that we have and give away as part of the program we're doing on January 21st next week, but you need to explain it to people and how it's going to work and what the timelines are. So the policy itself becomes more really of a program identity document than just a policy on how this goes, but it is a legal requirement to summarize your resolution process. And that means providing the name of the designated recipient of complaints right in the policy, not leaving it to chance, but to put it in, and you need to know who that person is. Then you also, as a prescribed element, need to have the process for when and how you're going to update your workplace violence and harassment risk assessment. That has to be said. Now, minimum under the legislation is 3 years, but if you have an incident, you also have to review your policy and your incident complaint process. So it's a little more complicated than just every 3 years, but it also includes every 3 years. So these are all prescribed elements of the policy, and they actually continue. There's more of them on the next slide. One of the requirements of the new federal prevention of harassment of violence regulation is development of emergency procedures. In other words, what do you actually do? Now, whether you want to have an active shooter policy, which is required by law in the US, or just a more general emergency procedures policy for dealing with harassment and violence incidents, that is a standalone separate policy from the prevention of harassment and violence policy, but you need to provide a summary of your emergency procedures in this policy. If you don't, then you've not met the requirements of the law and the policy. And if you don't have an emergency procedure developed, you must. That's an additional obligation under the new federal law. Your policy must also have a description of how the employer will provide and protect for the privacy of employees. And this means limiting to the extent possible, while still doing a proper and full investigation, the identity of the alleged perpetrator, the alleged victim or victims, and the people involved in the investigatory process. So privacy laws, as we generally refer to them, are really kind of confusing because there aren't a whole lot of privacy statutes, but there's a whole lot of privacy expectations, starting from Section 8 of the Charter of Rights and Freedoms, all the way through to the implications of the Supreme Court decision in the Irving Pulp and Paper case dealing with privacy rights that the court recognizes in a common law context of alcohol and drug testing. So advice on privacy is a sensitive issue. Getting people's consent is critical. One of the problems in many violence and harassment complaints, and my colleagues and I have been involved in many of them, is the issue of, well, I want to complain, somebody says, but I don't want anybody to know my name. Well, it's going to be hard if you don't know the name or the name of the perpetrator to actually investigate properly and to do whatever you have to do. And that's actually part of what's included in the regulations, how to deal with that. And so because the regulation deals with that, you have to identify this as in your policy, how you're going to protect the privacy of employees. You're going to have resource and recourse direction in the policy of what to do if there's an occurrence, who to go to, who to complain with, and then any support measures that are available. So all of these 11 elements are prescribed by law to be in your policy. Be sure that when you update it to be compliant, that you've met those legal requirements. If you're a provincially regulated employer, take a look at that list and ask yourself, does that make sense for us to put in our policy, even if it's not required by our provincial legislation? There's record keeping. On the next slide, there's record keeping obligations of the policy, and for want of time, I'm not going to go through them or read them. But these are new and they need to be understood by essentially HR and health and safety compliance management tools in your organization. So go to the next slide. The prevention regulations have to have a time frame, and the records that you're keeping must do what we've got on the slides. In other words, you've got to have a record of the timelines, and if you haven't met them for resolving the steps in the internal investigation and complaint procedure, why? We recommend you do your very best to follow the timelines, because it's going to be hard pressed if you're complained or get a complaint and a federal safety officer comes in and looks at it to explain why. The fact you were busy, the fact you were distracted with COVID challenges will, in my opinion, not likely be a good answer. And that could result actually in a direction, or quite frankly, even in a prosecution if there's a fairly flagrant violation of not investigating in a timely manner as required by the regulation. The investigator's report has to, in a summary form, be provided to the perpetrator and the complainant. You have to file an annual report now on your policy and your incidents of harassment of violence federally. And if there's a fatality, whether or not it involves harassment of violence, that's a new reporting obligation as well. So we'll go to the next slide. The resources, I think, Carla, you're going to talk a little bit about as we wrap up, and then I'll take a look and see if there's any questions that we may want to try and answer before we go on to David and Cathy.
Okay, just quickly, we just wanted to give you some of the resources that are available to you as you're looking at, well, what does this really mean for me? How do I either amend the policy and procedures I have in place, or maybe I have to start from scratch and develop something. This is on the www.canada.ca website. There is actually a workplace harassment and violence prevention tool. As I mentioned, there's a risk assessment tool, which is very comprehensive that you can use to adapt to your location. And then there's also a sample policy harassment and violence prevention user guide. So those are just some references for you on the federal side. And if we could just quickly go to the next slides. The next two slides I'm not going to go through. I didn't want to the provincial attendees to think that they were left out. There haven't been significant changes within provincial legislation. We've created a chart on this page and the next slide, and it just shows you where you can find the harassment legislation and violence legislation applicable to your province and territory. And I'm just going to leave it at that. And Norm, if there are any questions that you'd like to respond to.
Thanks, Carla. There was a question about the annual reporting to the minister. My understanding is there's not a formal form you fill out. It's often done by our clients that we review in a letter format. The information to be provided is set out in the Act and the regulations, but the format, as far as I'm aware, has just generally been in the form of a letter identifying the reporting obligation. But that's an off-the-top answer. I would have to double check if I'm giving a formal legal opinion, which I'm not. So I think that's us for Carla, and David and Cathy are going to take it over from here on workers' compensation. Thank you.
All right. Thank you, Cathy and Carla. We're going to change gears a little bit and talk about workers' compensation, claims management, and appeal strategies. Some of the changes that have happened over the last year, and we're going to talk about some best practices with respect to claims management and appeal strategies. As of January 1st, 2020, the WSIB in Ontario introduced their new rate framework experience rating system. Essentially, the rate framework replaced the other experience rating programs that the WSIB had, which may or may not have applied to your business, depending on what size you were. There were 3 experience rating programs in place, depending on the premiums that you paid and your industry and the industry that you worked in. So there was a construction, the CAD 7 program. There was the NEAR, new experimental experience rating program for non-construction employers. There was the merit adjusted premium program, and there was no experience rating for any employer that paid less than $1,000 a year in premiums. The WSIB changed all of that as of January the 1st, 2020, bringing in the rate framework. That new program applies to all employers, regardless of size and regardless of business activity. Employers have been assigned to industry classes based on the North American Industry Classification System, which is more regularly updated and consistent with your reporting to the Canada Revenue Agency. And of course, the WSIB still has the exclusive jurisdiction to determine premium rates that are associated with each of those classifications. The biggest difference with the transition over to the rate framework is the removal of premium rebates and surcharges. Those applied to both the CAD 7 and the NEAR program, and in my opinion, and in the opinion of many of our employer clients, made the system very volatile. Employers took specific action with respect to claims in order to mitigate potential premium rebates and surcharges. Everybody likes a rebate. And certainly, I was dealing with an employer this week who was getting a substantial rebate under the NEAR program, and was very happy about that. But on the other side, we also have clients that experience premium surcharges, and they spent a substantial amount of time throughout the year forecasting what their potential surcharge was going to be, so that they weren't going to surprise their senior management in November when they got their NEAR statement with a potential $500,000 surcharge bill. So those were those things all changed under the rate framework. Under the new rate framework, which again came into effect in January, employers have their own premium, have a premium rate, and that premium rate gets adjusted up or down depending on their particular claims experience, and the information used to determine the premium rate is claim count, so the number of claims that you have, both lost time and no lost time, claim costs, and insurable earnings, the level of insurable earnings that you have over a rolling 6-year period. That's another significant change with the rate framework. Instead of looking at claim costs over a 4-year period under NEAR or a 5-year period under CAD 7, the WSIB has moved to a 6-year review period, and that's consistent with the 72-month review period that's under the Workplace Safety and Insurance Act. What that means practically, though, is that even though claims costs would not have impacted you under, for example, the NEAR program, if you had a claim that was from 2016 under the NEAR program, it would only impact you for 2017, 18, 19, and 20. And as of September 30th of 2020, the claim wouldn't impact you anymore under the rate framework, because the board looks at 6 years of claims experience. It does continue to impact your experience rating and potentially your premium rate. So claims management and cost savings are continue to be important for a longer period of time under the rate framework. Significantly, because of COVID-19, the WSIB essentially put the rate framework on a bit of a hold. They had initially come out with a transition policy to fully implement the rate framework system beginning in 2020. But because of COVID-19, a number of measures were taken for rate stability, as the WSIB likes to call it. The WSIB had said that they were not going to adjust rates from 2020 to 2021. They were going to leave them the same. In accordance with that, they have updated their transition policy to begin adjusting employer premium rates, the employer level premium rates, beginning in 2022. So what that means, and the new policy outlines that if you are due to have your premiums decreased because your experience rating is good, you will receive the premium decrease that you are supposed to receive. If you are due to have an increase because you have increased claim costs, for example, that increase will be limited. In 2022, you would have a maximum increase of 5% from the 2021 rate. The following year, there could be a maximum of 10% increase from the 2022 rate. And then by 2024, the rate framework is going to be fully implemented. What that means is that the WSIB has incorporated certain insurance aspects into the rate framework. They limit the amount that your premium can be adjusted in any 1 year, because they don't want to have, they don't want to be essentially shocking employers with overly significant experience rating increases or decrease. But when the program is fully implemented, the maximum swing an employer could have in any 1 year is 15%, up or down. So that limits your potential exposure. The important thing for employers to pay attention to with respect to the rate framework is when you get your premium rate summary from the WSIB, it tells you what your projected rate is. So you see what your current rate is and what your projected rate is. If your projected rate is higher than your current rate, that tells you that you're on an upward trajectory and you really need to pay attention to your claim costs and your claim count and try and reduce those as much as possible. If you're on a downward trajectory, that is always a good sign. Paying less than the than you're currently paying is definitely good, and you're happy to have that. You won't get a premium, you won't get a rebate anymore in terms of a lump sum, but it will happen throughout the year. Okay. Another significant change that happened as of November the 30th, 2020, was the WSIB consolidated their return to work policies. They essentially consolidated approximately 6 policies into 4. In my opinion, the new policies and the way that they're written are much cleaner. They are, again, in my opinion, clearer in what's required, although the specific requirements for employers have not really changed with the updated policies. There are 4, so they consolidated the 4 policies into the ones that are seen on the screen. Return to work overview and key concepts. Though that policy defines things like suitable work, available work, and what the roles and responsibilities are. Under Section 40 of the Workplace Safety and Insurance Act, there are responsibilities for both employers and workers to cooperate and return to work. These are discussions that we have with our employer clients all the time about what does cooperation mean, and we'll talk about some claims best practices shortly. And Cathy's going to jump in and help out with that. There are return to work cooperation obligations, essentially the duty to accommodate the work in the workplace to the extent of undue hardship, which is the same as under human rights legislation. So there is a duty to cooperate with respect to return to work and potential penalties for failing to cooperate with respect to return to work. It's insufficient to just say we don't have work available without undertaking some sort of investigation to see, do you have any postings? Do you have the ability to accommodate the work temporarily or potentially permanently so that this worker can it can continue to work? There are limitations, of course, but you do need to undertake the exercise, and the WSIB will be involved in that as well, with the help of return to work specialists. For employees that have been with you for at least a year in the non-construction world, if the employees have been with you for at least a year, there's the potential for a reemployment obligation to apply if the worker is unable to work. And what that means is they've either lost time due to a workplace injury, or they've required modified work. Both of those things fall into the definition of unable to work. In that case, the reemployment obligation may apply, and you have a duty to reemploy the worker. And again, going along with the cooperation obligation, accommodate the work in the workplace. Essentially, the reemployment obligation protects workers from being terminated for any reason to do with the injury or claim for benefits. We had a lot of questions about whether that means you could never terminate a worker, and the answer to that is well no, but you need to be very mindful of the reasons for that, and the reasons for the termination. If the termination is at all related to the injury or claim for benefits, then you could face a potential reemployment breach determination by the WSIB, and there's a significant penalty that can go along with that, in addition to the experience rating hit that goes along with paying additional benefits. The final policy up here on the screen is return to work assessments and plans. This policy is, in my opinion, a lot more clear about what will happen with respect to return to work with the injury employer, if at all possible, or in the general workforce, if a return to work with the injury employer is not possible. What actions will be taken by the WSIB, what assistance is available for workers, and the potential outcomes for that. For those who have been working in the workers' comp world in the WSIB for a long period of time, the labor market reentry program was replaced with work transition. They have now moved over towards return to work assessments and plans, and that plan may assist a worker with returning to work in a suitable occupation in the same course as used to happen under the labor market reentry and work transition programs. Just briefly, the return to work policies have not changed in that employers remain responsible to offer work that's suitable and available. Suitable means work that's safe, productive, and consistent with the worker's functional abilities. Safe not only for the injured worker themselves, but for others around them. And safe in terms of, can they get to work? Can they get to the workplace? So all of those things need to be considered. Is the work productive? Back when I started adjudicating WSIB claims, productive was a bit of there were a lot of different definitions with what was considered to be productive. And a lot of work that was being given to workers was not productive. But the policies outline what productive means. It has to be meaningful work, something that somebody else would be required to do in the workplace and that you would normally pay somebody for. So is it productive? Is it valued work? And is it consistent with their functional abilities? You, as the employer, always have the right to learn and know what the worker's functional abilities are. What is it that they can do in order to be able to try and put a successful return to work program in place? You can provide work that's available at the pre-injury or at an alternate work site. In certain circumstances, you might be able to offer work from home for a period of time, for example, if there is additional work that's available. But those situations need to be reviewed with the WSIB on a case-by-case basis. I tell employers all the time that there is no silver bullet with respect to return to work, and your obligation is to offer work that's suitable and available. The worker's obligation is to accept the work and to do it if it is suitable. And if there's any dispute, then that can be reviewed with the WSIB in order to have them make a determination. I touched on the reemployment and cooperation obligations already. These are overlapping obligations. It's not one or the other. In certain circumstances, the reemployment obligation does not apply. In the construction sector, it always applies. It doesn't matter how long a worker has been with you. For employers who are non-construction, the reemployment obligation would apply whether only if the employee or the worker has been with you for at least 12 months. I use the term worker because that's the term used in the legislation. It encompasses workers, not employees necessarily. The cooperation obligation can last up to 72 months post-injury. Now, typically, matters are resolved well before then, but essentially, you have an obligation as an employer to offer suitable work that's available. The cooperation obligation can end when the WSIB is satisfied that there is no suitable work available. And we're running into a number of situations now, for example, and since COVID-19 has really hit a number of industry sectors really hard, where there have been a number of downsizings, a number of closings, for example, where suitable work is potentially not available. The cooperation obligation can also end if the employment relationship is ended, either because the worker voluntarily quits or because they're terminated for reasons unrelated to the injury or claim for benefits. It can also end if the WSIB determines that the employer has offered work and the worker does not accept that work. In those cases, if the WSIB is satisfied that suitable work is available and there's no wage loss associated with that work, if the worker doesn't come back to work, then the remedy is to not pay wage loss benefits to the worker. And the worker does obviously have the right to appeal that decision if they disagree with it. But it's important to pay attention to the cooperation obligations. The WSIB will work with you and offer return to work services, bring a return to work specialist into the workplace to help try to resolve any disputes. They act as mediators as well. So it's important to avail yourself of those services. I'm going to turn the floor over to Cathy to talk about some best practices.
Thanks, David. So certainly anyone that's responsible or had responsibility for managing WSIB claims knows that it can be quite challenging at times, dealing with a lot of barriers. So I'm just going to talk about some best practices with respect to return to work, claims management, and appeals. So starting with return to work best practices, if at all possible, identify your modified work jobs ahead of time, so you're not scrambling to find modified work for a worker at the time of injury. It's also really important to offer any suitable alternative or modified work in writing. So specifically outline the work that's being offered. Don't just generally say that we have a modified work program. Specifically detail the work hours that you expect the worker to work, and be specific with respect to the date that the modified work will start. So this level of detail, this return to work or modified work plan is really going to be important if you're ever trying at any point to demonstrate to the board that suitable modified work was offered, the worker didn't accept it, and your position is you'd like their benefits to be reduced or suspended. It's also important to make sure that you've got up-to-date information on the worker's functional capabilities and limitations. That's going to help you to be able to identify suitable modified work that's within their capabilities and limitations, help you to determine the type of modified work that they can do, and whether or not they've got any restrictions on work hours and things like that. And because not all cases are going to go smoothly at all times, it's really important to advise the board in writing of any issues that you're experiencing in the return to work process. So this could include situations if a worker is refusing the modified work that you've offered, if they're not working the hours that are set out in the plan that you've offered. So it's really important to monitor that aspect, or if the worker stops coming to work, or if they're just continually leaving work early for whatever reason. So essentially the board should be kept apprised of any barriers in the return to work process. Next slide, please. Some claims management best practices. Number one, ensure timely and accurate claims reporting. This is pretty basic. You don't want to be hit with a late reporting penalty. You can avail yourselves of the services of the WSIB, their e-services, to upload information. Make sure that you've got copies of decision letters from the WSIB. And if you don't, and you think that a decision has been made and a decision letter hasn't been issued, then follow up on that. One reason for doing this is that you can appeal decisions that you don't agree with, and you can't appeal something if you don't have a written decision to appeal. Look for cost savings opportunities. So this could be from cost transfer application if you feel that there's third-party negligence involved in a claim, or there could possibly be evidence of a pre-existing condition. So you're asking for cost relief. So this is also why, especially with the cost transfer issue, why it's really important that you do a very thorough and detailed accident investigation when a worker injures themselves. You might find evidence of third-party negligence, in which case you might be able to get all or a portion of a worker's claims cost transferred to the claim cost statement of another employer or employers, plural. You can also ask the board for cost relief if you have reason to believe that a pre-existing condition caused or contributed to or is possibly otherwise prolonging a claim, and make sure you're putting all of these requests in writing. And finally, if you disagree with a decision, absolutely exercise your right to appeal. Make sure you do it within legislated timelines. Next slide, David, just continuing on with appeal best practices. So you want to obviously maximize your potential for success in an appeal application situation. So number one is making sure the WSIB has got all of the relevant information that you think they need to make a decision. So this might include things like making sure that they've got a really detailed description of the job or the work that's being offered. If you can provide a physical demands analysis, if you've got those available at your workplace, that would be helpful. Any reports from independent medical exams, so the board's got all of the relevant objective medical documentation on file. You can use, again, e-services to obtain claim file documents. Review those claim file documents really carefully. Oftentimes you might see something to indicate, for example, that the worker has a pre-existing condition. You might be privy to medical documentation in a claim file that you wouldn't have otherwise seen if you didn't have access to the claim file. And finally, do your homework. If you're doing an appeal, you want to ensure that WSIB decisions are consistent with facts and applicable law and WSIB policy. So this might mean that you take a look at the Workplace Safety Insurance Act relevant provisions that you're dealing with, or the board's operational policies. And finally, I'd also recommend, if you go onto the WSIAT, Workplace Safety Insurance Appeals Tribunal, WSIAT website, you can search for cases and decisions that have dealt with the same issues that you're dealing with in your appeal. And oftentimes this information is really quite useful. So that's it for the WSIB session, and it also brings us to the end of our presentation. Norm, I'll pass it back to you for any final words and to do a final wrap up and make sure we've answered everyone's questions.
Thank you, Cathy. Thanks, Carla and David. Obviously, this is a little different this year. We want to thank all of you who have trusted us to retain us to help with advice and representation throughout 2020. It's been an unusual and challenging year. In fact, the year in review usually is done in late November, early December, but for a lot of reasons, it made more sense to do it now. The couple of the questions I'll answer briefly. The information on the new regulation under the Emergency Management and Civil Protection Act, so it's an actual regulation under that statute, is being updated on Fasken's website. If you want to go to fasken.com, it's easy to find, and there's resources, and some of the obligations that are new or have been changed are set out there fairly clearly. If you're an employer who believes they're an exempt employer that can have employees coming into the workplace, you will require them, in most cases, to have a letter of approval, because as they walk, take public transit or drive, and then park and attend your workplace, you may be stopped by a police officer, bylaw officer, or a Ministry of Labor Training and Skills Development provincial offenses officer and asked about your right to be going to the workplace. We can help as a leading law firm in the area. Prepare an appropriate letter that you can use for your employees so that they don't get into difficulty with authorities and that you're seen as an organization and employer to be fully compliant. There is probably, in the early days of this state of emergency, little risk that there'll be a lot of enforcement or issuing of tickets or prosecution under provincial offenses legislation. However, depending on the discretion of the enforcement official you meet and the interaction they have with your employee, which may not go perfectly, you may have to face that. One of the key elements of any type of regulatory enforcement for your workers, but more importantly for you as an employer, is to make sure that you've taken the reasonable precautions or due diligence. So although we've talked about due diligence today in a safety context, it would apply in our view likely as a defense to compliance with the new regulations under the Emergency Management and Civil Protection Act. So in other words, ask yourself the question, do we have a COVID safety plan in place? Has it been updated to be consistent with the new and more rigorous rules that were passed late last night? And you know, in the next hours and days as you adjust to this new normal, and maybe for a month, it may be for a lot longer, we're not certain. If you need help, I'd encourage you to reach out if you're a Fasken client to the normal labor and employment lawyer that you deal with. And if you aren't a Fasken client or want to contact one of the presenters today, feel free to do that. We're going to go to a slide with our website pictures and contact information. And we want to communicate very clearly our appreciation. We look forward to serving you in 2021, but in this unique situation where less than 24 hours ago, we have new rules to cope with this COVID state of emergency. We want you to know that we care about you as clients. We want to see you compliant and still do the best to operate your businesses and organizations throughout this challenging time, and we're there for you. So thank you again. Thank you to my co-panelists again. Hopefully, if we do this at the end of this year or early next year, we can do it in person. It's much more rewarding, I think, from our perspective to actually see people we know, see new friends, new clients, and present in person and answer your questions orally and spontaneously rather than through the chat function. But thank you for hanging in there with us. We're continuing to be available, and all the best in your new year of 2021, both personally, professionally, and for your organizations. So thank you again. And again, if you have questions, there are some contact phone numbers and emails. Feel free to get a hold of us, as we may be of help to you. So thank you, and hope you have a great day. That's it for now. Bye-bye.